Hello friends, in the series on the income tax cases, today we will discuss a case which has been decided by the Honorable Madras High Court, and the issue before the Honorable Madras High Court was that whether the decision given by the tribunal in favor of the assessee based on the judgment of the Supreme Court in the case of Union of India versus Ganpati Dealcom Pvt Limited in respect of transactions which were alleged to be as Benami and which were incurred before 2016 can be withdrawn just on the basis that the revenue has filed a review petition against the order of the Honorable Supreme Court. This issue has been taken up by Honorable Madras High Court in the case of Deputy Commissioner of Income Tax versus Marg Limited, and this case is reported in 477 ITR page number 521, and the date of the judgment is 8th January 2024. The facts of the present case are like this. In the present case, the assessee has entered into some transactions which were related to a period before 2016, and when the matter of the assessee was pending before the tribunal allowed the appeal of the assessee by saying that the Prohibition of Benami Property Transaction Act 1988 will not be applicable for the transactions prior to 2016, and that tribunal judgment was based and by following the judgment of the Honorable Supreme Court in the case of Union of India versus Ganpati Dealcom Pvt Limited. After this decision, the revenue filed a review petition in the Supreme Court in the case of Union of India versus Ganpati Dealcom Pvt Limited, and based on that review petition, the revenue also filed the appeal in the Madras High Court, and the plea of the revenue was that since the revenue has filed the review petition in the Supreme Court, so it means that the decision of the Supreme Court will not be applicable to the assessee. This was the main plea of the revenue. So when this matter was heard by the Madras High Court, the court said that the High Court in a batch of similar cases has decided that the order of the tribunal should not be interfered just on the basis that the revenue has filed the review petition in the Supreme Court. So in the present case also, by following the same judgment of its earlier judgment, the Madras High Court declined to entertain the appeal of the revenue in the present case and said that the order of the tribunal should not be interfered just because the revenue has filed a review petition in the Supreme Court against the judgment of Union of India versus Ganpati Dealcom Pvt Limited. But at the same time, the Madras High Court gave a liberty to the revenue that whenever there will be the decision on the review petition filed before the Supreme Court, then on the basis of that decision, the revenue can further appeal in this matter. So the right of the revenue were also preserved, and at the same time, the Madras High Court upheld the order of the tribunal. Friends, from this case, it becomes very clear that as on date also, the rule is the same, that the Benami Property Transaction Act 1988 will not be applicable for the transactions that has been entered before 2016. But whenever the review petition will be heard by the Supreme Court and decision will come, then on the basis of that judgment, all the fate of all these cases will again be decided. Friends, this case is very important because these type of matters will also applicable in other cases also, where the matter is pending before the Supreme Court in the review petitions. So whenever the review petitions are filed, the revenue become over enthusiastic and files the appeal in the higher forums and just take the plea of that. So from this welcome judgment, it becomes very clear that just because of filing the review petitions, the matter does not get alive, but it will get alive only when the decision of the review petitions will come in favor of the party who is going to seek the appeal against the order. At the end of this video, once again I am repeating the name of the case. The name of the case is Deputy Commissioner of Income Tax versus Marg Limited, and this case is reported in 477 ITR at page number 521, and the date of the judgment is 8th January 2024. Thank you, friends.